It's the reserved category should have been put to.
Outcome, we'll say.
Right, it appears this is a 22 notification.
So, yeah, 22 notification.
Yes, provisional selection list was published on August.
27th August, my lord.
We'll say any selection pursuant to the notification towards SC reservation. Insofar as SC reservation is subject to outcome.
This is ST, my lord.
ST,
ST, my lord. ST, my lord.
His contention is the unofficial response was more meritorious.
I've seen that.
He should have selected
Against the OC vacancy, then he
category.
could have got.
Yes.
My lord, actually, when I have personally, when
Your lordships may post it immediately after vacation, my lord. This post, one post maybe, because that's the only post. The last post, my lord, your lordships may direct to. My lord, we'll file a counter by that time. In fact, the regular council also may come on record, my lord, by the date.
This will post on 14th.
my lord, actually, when I visited personally, my lord, the Public Service Commission has told that ST vacancy has been adjusted in such a way, they have given me
That
19
we will consider after filing of counter.
My lord, that is true. That is true, my lord. But the thing, they have actually, they said that
At request of the standing council to get instructions post on
Milord.
16/10. Till then, the response are directed to keep one post vacant in the cadre of veterinary assistant surgeon
in ST
Division
category.
1 in pursuance to the notification number 23 of 2022 dated 22/12/2022.
Category also. Category, your lordships.
Category, anyhow, he has to be adjusted
ST.
against OC, my lord.
Let ST.
In the
or
ST category.
ST or OC, because one has to go
Yes.
up. my lord.
One post has to be reserved, my lord.
Yes.
Obliged.
Next.
Much obliged.
Result of group 1.
No, Your Lordship, another connected.
Dismissal
matter.
order.
No, no,
Yes.
Sports matter.
Lord.
Matter.
My lord, this is pertaining to sports quota, my lord. Lordships posted two matters together today. But
Yes.
the other matter, which was pertaining to agriculture officer, and this is pertaining to AVI, both of them, the issue is the same thing, my lord, form 2. So the other matter is not listed, but Lordships can pass an order in this, the Lordship so pleases, to keep one post vacant, because
What is the
finalization,
stage of recruitment?
selection is over. Selection is over in the sense, my lord,
We'll
verification
see,
is
we'll post this matter on 14th, get instruction, Rahul. I request the standing council to get instruction, post on 14th in the urgent motion list. Let him get
Alright.
instructions.
no, but till that time, my lord, give some protection, my lord.
No.
Till that
See,
time, my lord,
recruitment is already over.
over, my lord, that's what, it's not completed for us. Selection is not finalized. Select
14th,
list is
we
not,
will see on 14th.
no, let keep one post vacant, that's all, subject to outcome, my lord. Let them not finalize, because the same issue. But they cannot have two different yardsticks for two different recruitments.
If the
I'm only
recruitment is already completed, what can we do?
Completed, but final list is not given. I'm only saying don't fill up one post. Just the way your lords are protected in the other case, your lords may protect by one post may be kept vacant. That's all. There is not a single sports person is selected.
Milord, in this, Milord, since your lordships have taken the view on the other in the other cases, Milord, vacate stays are also filed. Milord, here selection is over. That means already that ratio, Milord, into open category candidates must have already been called and selected. Milord, at this stage, without making the concerned necessary
At
party,
request of the standing
that will be a
council
difficulty, Milord.
to get instruction post on 18th. Till then, any selection pursuant to the sports
Subject to,
quota,
subject
under
to
sports quota in pursuant to the notification number
31 of 22.
31 of 2022, dated
31/12/22, Milord.
31/12/2022. What is the date of notification?
Notification date is
Dated
31.
31/12/2022. The notification number 31/2022. Subject to outcome of the repeat. Post on 18th.
My lord, your lordships may also direct the Public Service Commission to give the last candidate selected against, because we will not be knowing, my lord, the Public
No,
Service
Rajshekhar is not here. We'll ask. On that day, we'll see. 18th, yes.
Adjourn motion.
Obliged.
Adjourn motion list, Your Lordship.
Huh?
Adjourn motion list.
In the urgent motion list.
Applies.
Yours. Yes, 58. Who's below number? Yes, sir. What is this matter?
My lord, this is the case of termination.
Dismissal. Yes, notice.
My lord,
What
I'm
is-
only asking as an interim direction, my lord. I know that your lordship, this is for removal. Actually, what has happened, my lord, based upon the complaints, my lord, charge memo was issued and all the complaints came in the
That we will
report.
consider, take out personal notice.
I will take out, my lord, I'll just only seek your lordship's intelligence to this extent. My lord, he is already terminated.
Not today. If you, we will adjourn this matter on 14th, we'll post on 14th.
No, I'm only
Want
saying
to
this, my
argue
lord.
a case? Yes.
No, I'm only saying not to insist upon payment of loans till that time because Nakameda Mulge Nakameda Tatke Badnatu, he's already removed and then he's asked he's asked to pay. That may be someone is unable to pay my fees also, leave alone paying loans. So I'm only saying let them not pay, let them only not insist for payment of loans, my lord, which he took from the bank. With a wishful thinking, my lord, he has purchased. Some complaints are made. Complaints have withdrawn their complaints.
Notice
But
for
still,
admission, issue notice to 1 and 2, if person is permitted to take out personal notice to R1 and 2. Post on 7/11, till then the responsible directed to not to insist for payment of loan, amount taken by the petitioner.
obliged.
Post on 11/7, in the urgent motion list, yes.
Obliged.
Yes, I can, yeah. Extension of intermodal, learn. SGP, services 1. Yes, at request of the petitioner, respondent, government feeder, post after 4 weeks. Yes. What is the next? Rohit.
This also to counterpart.
At request of the government feeder, post out 4 weeks. Till then, intermodal shall stand extended in both cases. Amma. Same, at request of the respondent, post after 4 weeks. Till then, intermodal shall stand extended. 2 weeks. 4 weeks or 2 weeks?
2 weeks.
Yes, at request of the parties, post out 2 weeks. Till then, intermodal shall stand extended.
I filed vacancy stay, my lord, in this case. Last we extend for 2 weeks and
2 weeks at request of the parties, post after 2 weeks. Till then, intermodal shall stand extended. Yes. 2 weeks. 2 weeks. Till then, intermodal shall stand extended.
In my case, extension already interim is there until further order.
So 73 delete from the caption of the extension of interim order. 72 post after 2 weeks. Till then, intermodal shall stand extended.
In this matter, my lord, we filed a vacate stay. Lordships were pleased to grant status quo in matters of transfer, my lord. The persons, my lord, they were to be transferred, compulsory transferred, my lord, under the 40%.
Medical and health department.
Yes, my lord. By
Will post on 17th or 18th. Today or tomorrow.
No, my lord. I leave to your lordships. There's urgency in the matter, but
Post on, if request for the parties, post on 18th, 17th, till the intermodal shall stand action. 17th, 10. Yes. Same, 4 weeks, till then intermodal shall stand action. 76, 77, post after 2
Same.
weeks.
Same, my lord. These are all
Connected to?
yes,
No.
medical and health.
Yes, say post on 17th, till then intermodal shall stand action. This is also connected, 78.
No lodge. This lodge to wait.
Yes, post after 4 weeks, till then intermodal shall stand extended.
Less.
Yes, 4 weeks, till then intermodal shall stand extended. Same, you are up there.
I filed a vacate petition. There are 2 persons now.
2 weeks, till then intermodal shall
The
stand extended.
status quo is granted. No?
2 weeks. Or 17th we will post on. 7th, at request of
Last may
the,
post it on 15th,
no,
16th. Because there are 2. no, both-
16th, till then intermodal shall stand extended, yes. You are applying for the board.
Corporation.
Corporation, yes. 16. Yes. What is the issue matter about? We'll see after 4 weeks. Now, at request of the respondent, post out 4 weeks, till then intermediate shall stand extended. Yes, 4 weeks, till then intermediate shall
This
stand
matter
extended.
is not showcase notice, my lord, that predetermined.
What do you want now?
Your Lordship, remind the matter afresh, my lord,
We'll see after 4 weeks. 4 weeks or 2 weeks?
2 weeks, my lord.
Yes, 2 weeks till then intermediate shall stand extended. Yes. Yes, call the group 1 case. Huh? No, 250 matter today is not possible. We'll see after completion of this one.
My lord,
After completion
Yes,
of this matter,
yes,
we'll see.
There's an interim order, my lord, it can be extended.
No, we are not adjourning. After completion, we'll see.
You may not reach there other than waiting.
When do you want Rahul?
but tomorrow, my lord, there is
Tomorrow.
entire state, my
Tomorrow,
lord,
till then
still
intermediate shall stand extended.
I'm obliged.
Subject to.
Tomorrow,
we'll
nothing is
we'll-
happening.
we'll-
Nothing
we'll-
is happening.
In January, somebody is retiring is what I am told. My friend says that nothing is happening, I don't.
From today
Only-
today to tomorrow.
No, tomorrow you know, taking up tomorrow.
Yes, yes, sir. Tomorrow.
Special GP is insisting for hearing.
Fine. That's what I thought that being adjourned after vacation.
Yes, yes, no. Yes. Yes. After completion of group 1 case, we will take up. If it continues tomorrow also.
Lord, your lordships may kindly be taken to writ petition 21239 of 24, my lord.
అది ఇవ్వండి ఒకసారి అది ఒకసారి ఇవ్వండి ఆ కట్ట ఇవ్వండి
Dear.
1 minute.
Yes,
Before commencing your arguments, please clarify.
my lord.
You want to argue 21239.
239.
So in this case 239
My lord.
or petition number third petitioner was submitted objections.
Yes, my lord.
Out of these 3 candidates, how many candidates were qualified?
1 and 3.
1 and 3.
1 and 3 are qualified for mains. And the only person who submitted objections is petitioner number 3 and is qualified. 1 and 2 have not submitted any objections in respect of the questions. But my lord, 1 also is qualified.
1 also?
Is qualified. Petitioner number 1 also is
Yes.
qualified.
And in this case 22320, how many candidates are qualified? No
In
one.
that 5 of them not qualified, my lord, out of 5, 4 did not submit any objection.
Who has submitted objections?
Only petitioner number 1 has submitted objections.
Only petitioner.
Ripoda.
But if I may just give a sorry, just in respect of the questions, my lord, which they have raised, my lord, what objections? Who have raised the objections? Who have not raised the objections? My lord, is
No, how many petitioner number 1 has raised objections for how many questions?
7.
7. What
In
are
the
those 7?
in the second case, my lord.
In 22320.
In 22320, 7 questions.
7
are raised.
questions. What are those questions?
That I've just circulated, my lord. This one. Next page, my lord. Your lordships would see.
These are those questions.
Yes, ma'am. Question 41 Second page, my lord. The first page is, my lord, the first case.
Yes,
Question 41, he has raised the objection.
yes,
Tick, my lord, wherever there is tick, my lord, he has raised the objection.
yes,
My lord, wherever they have not raised the objection, it's an into.
yes.
My lord, 41, 66, 79, 106, 116, 119, 139. These are the only objections, my lord, there he has raised.
Seven questions.
That's
Seven
it.
questions.
7 questions. Lord, incidentally, out of the 7 questions, my lord, in 22320,
Yes,
the first question, item 41, serial question number 41, Lord, in tune with the key given by the Public Service Commission, 3 people have answered correct. Petitioner number 1, my lord, question number 1, where he has raised an objection. In fact, he has matched the answer with the Public Service Commission. He got a mark for it. So, my lord, by objecting to the answer, my lord, he will be losing a mark for himself.
yes,
My respectful submission is 41. Though he has raised an objection, in fact, his whatever answer that he has submitted in the OMR is correct to
Yes,
the
sir.
final key.
yes, final, yes,
3 also, my lord, in the same thing, P3 also, my lord, though no objection has been raised, my lord, none of them, your lordships would see 2, 3, 4. No one has raised any objection to this in respect of these questions.
which question? 66.
My lord, all the questions, your lordships would see, my lord. Petition number 2, 3, 4 in the second question, second case, none of
Yes.
them. No, my lord, only ticks they have raised the objection. No tick means, my lord, it's into, means they have not raised any objection.
Yes.
Except the first petitioner, 2, 3, 4 have not, 5 have not.
submitted any objections. Yes.
Lord, in respect of the first question, my lord, and 66, my lord, is one objection raised by only petitioner number 1.
Yes,
And 2, 3, 4, my lord, have not raised any objections.
yes,
Lord, in fact, even in the first case also, my lord, only petitioner number 3 has raised the objection, but is qualified for mains.
yes,
So, my lord, unqualified persons, my lord, those who could not qualify for mains are only before your lordships. My lord, who have not raised the objection in the first case. That's only one petition. Lord, insofar as the second case is concerned, my lord, only petitioner number 1 has raised the objections. Out of 7, 1 he has attempted correct. Therefore, my lord, I am, Lord, 6 questions, my lord, other than what they have raised in the writ petition, 6 questions are there, which I have to answer. Because there are other
So,
questions they
can
have
you
not
produce
raised.
the merit list? Is it possible?
Merit list, my lord, we may, my lord, but that's only to show how close they would be. That's also we can. But the issue here is, my lord, the questions and answers, the material which they have placed, that in fact, from the same books also we have some material, my lord, which
Proceed, but produce
Now-
the merit list
Yes,
tomorrow,
ma'am.
2:15. Now proceed with the case.
yes, ma'am. Lord, first, my lord, 21239, your lordships may. Lord, kindly be taken to the prayer, my lord.
1 minute.
Yes.
Yes, Rama.
My lord, 21239, my lord, prayer, my lord, your lordships may kindly be taken to the prayer of the writ petition.
Yes,
21239, my lord, prayer.
yes,
Lord, it's a very lengthy prayer, my lord.
yes. Page number
First, Lord,
31.
main prayer, my lord. Yes, my lord, 31. I'm sorry.
30.
30. It starts from
read.
30, my lord.
Yes,
A call for the records pertaining to the web note dated 19/2/24, through which earlier notification was cancelled, and consequential second notification dated so and so, and set aside them as bad, illegal, unfair, unsustainable, unconstitutional, besides contrary to public interest and contrary to the directions of the Honorable High Court and Lord in writ petition division bench, and consequently direct the first respondent to conduct fresh preliminary examination. The ultimate goal is not about, my lord, new notification, new preliminary exam. They want one more preliminary exam because they failed. Now, then your lordships may kindly see, my lord. Alternatively,
Yes.
then they go again. Alternatively, declare the 503 vacancies notified in pursuance of the first notification be confined to those who have applied and participated in pursuance of the said notification. And consequently, direct the Public Service Commission to segregate the 563 vacancies into 503 old vacancies, 60 new vacancies, and confine consideration separately, my lord. This is beyond the scope, my lord, after participating. They have all participated now because they have not, two have got come to mains. Only for the purpose of one petitioner, they want the entire exercise to be done. And then third one, declaring the entire extension of time by 2 days beyond so and so to apply in pursuance of notification granted by Public Service Commission, leading to unnecessary expansion of competition and aiding those who did not apply them and so within time as bad, unconstitutional, and consequently set aside the second notification and to delete competition those who applied beyond. That first prayer is to cancel the notification. Second prayer is to segregate the vacancies and continue. Third prayer is to, my lord, to segregate the dates, my lord, from which they have come. My lord, fourth prayer, declaring the action of PSC in prescribing 10% second notification of 503 vacancies as well though so and so is prospective as bad, illegal, so and so. That 10% reservation. And then hold preliminary examination held on 9/6 so and so as illegal, unsustainable, and flaws, blunders, incorrect answers, and consequently direct. And respondent to conduct fresh preliminary examination.
Yes.
Lord, my respectful submission is, my lord, your lordships would see there is nothing with respect to key. There is nothing with respect to any prayer with respect to the key.
Yes.
It's all, my lord, only the writ petition is nothing to do with key. The prayer, my lord, ultimately we are going by the prayer.
Yes.
There are 5 prayers, my lord, all of them relate to only cancellation of the test.
Yes.
But and paragraphs 1 to 42, my lord, talk about various procedures, my lord, and all these reliefs that they are seeking. Paragraph 43 is the only paragraph which talks about key.
Yes.
And it, my lord, one important factor, my lord, the preliminary examination is for 150 questions with 4 multiple choices. Public Service Commission released prelims on so and so. Petitioners submitted their objections for 15 questions. And PSC released the final key, and as usual, 2 deleted, thereby final list. They are the different types of questions that you have to be placed before your lordships, my lord. Except one petitioner, no one has placed the objections, and that one petitioner, my lord, is qualified for mains. Lord, this is more in the nature of a public interest litigation, is my respectful submission, my lord. Lord, and also, my lord, the first notification, Lord, was issued on 26/4/2022, Lord, which came to be, Lord, challenged twice on the preliminary counts. Lord, then there is 2 dates, important dates, my lord. GMS number 33, first notification dated April 22.
Yes.
By which date, my lord, 503 vacancies were notified.
Yes.
GMS number 33, my lord, giving 10% reservation came up on 13/9/2022.
Yes.
Lord, then GMS number 16, Lord, this is very important. GMS number 16, GO issued by the state on, I'm sorry, my lord, on 3/2/2024. 3/2/2024. In between, my lord, the preliminary examinations were set aside. 3/2/2024, my lord, indent received from the government to add 60 more vacancies to the Group 1 exams, my lord, 503 plus 60. My lord, then GMS number 29 was issued.
Yes.
Lord, modifying the selection process
Yes.
as given in GMS number 55, originally was given, my lord, 1:50 ratio. That process also was modified.
Yes.
In GMS number 29. That is also, my lord, subject to challenge before your lordships as well as the Honorable Division Bench, my lord. No orders have been passed as on today. My lord, pending all this, my lord, these matters went up to Honorable Supreme Court, my lord. That is also matter of fact.
What is GO 16?
16, my lord, the 60 vacancies were given, indent was given, my lord, to add to the group vacancies.
Yes, yes,
So instead of 503, we were to notify 563 now.
yes.
That a web note was given on 19th Feb, cancelling 19th February 2024, cancelling the notification,
Yes,
earlier notification, and issuing fresh notification, my lord, on the same day,
yes,
19th February 2024.
yes,
In that, my lord, it was also made clear that persons who have already applied earlier need not pay the fees. They can just,
Yes,
they have to apply, but no fees to be paid.
yes,
Incidentally, my lord, all the petitioners, my lord, in both the writ petitions have applied for the exams, my lord, fresh notification. They have participated.
yes,
Lord, extension of web note, my lord, was also given because there was a technical glitch, my lord. Several of the persons, my lord, within the time, my lord, due to the technical glitch, many persons were, my lord, disabled from making their applications. Therefore, a decision was taken, my lord, to give the benefit. Because this Group 1, my lord, is issued after 10 years almost, my lord, they are for the first time. They should not be at loss, my lord. Therefore, 2 days extension was given. In the 2 days, my lord, a total of around 29,000 applications were received. Lord, and then the preliminary exam was conducted. Thereafter, my lord, a preliminary key was published on 13 June 2024.
13?
13 June 2024, preliminary key, my lord.
Key, yes, preliminary key,
Yes, my lord.
yes,
And then, my lord, the objections were invited
yes,
between 13 June 2024 to 17th June 2024.
13 to 17.
17, 5 days, my lord.
Yes, right.
In fact, my lord, petitioners all claim that they have made objections, my lord, submitted. No doubt, my lord, they have not. But they all have participated consciously knowing, and they are also, my lord, submitting objections. My lord, and then, my lord, 24th June
Yes,
24, their OMR sheets also were made available for them to, my lord, to see what marks.
yes,
The total objections, my lord, around 6,417 objections were received, my lord.
yes,
Total applicants, total persons who took the exam is 3,02,172.
yes,
Out of that, my lord, 6,417 objections were received from 1,721 candidates. Lord, we've gone further, my lord, a little bit deep into these statistics. Out of 3,02,172, 1,721 candidates raised objections.
3 lakhs,
3,02,172 persons, my lord, candidates took the exam,
appeared, yes,
appeared, my lord. Out of that, only 1,721 have raised the objections.
yes,
Lord, after this, my lord, after receiving of these objections, my lord, an expert committee was constituted to look into the
how many
objections.
candidates are qualified?
33,000. I'll give that number also.
Yes,
Final key was published, my lord, on 7th July 2024.
yes,
But thereafter, my lord, the first writ petition before your lordships, my lord, is filed on 31st July 2024, which is writ petition number 21239 of 2024. That is after nearly 23 days after final publication of final key.
filed on,
31st July 2024. The second writ petition, my lord, is filed on 13th August 2024,
yes,
close to, my lord, more than a month after the final key is published.
yes,
But a total of, my lord, I'll give a number, my lord, around 33,000, my lord, have qualified for the
can you say the cutoff, that will be subject, I mean, category wise?
each category wise. I didn't get that, my lord. I'll place that also.
Yes,
Now, after this entire episode of 31st July 2024, the first writ petition, my lord, I read through your lordships, my lord, the prayer.
Yes.
Consciously, they have participated from February at every level. They took the exam, they raised the objections, lord, and then they got to know their marks after the key. After everything failed, lord, they wanted to take a chance. They, for whatever reasons best known, my lord, they have come.
Yes.
My lord, even though, my lord, it is like this, my lord, even though they would have got certain number of marks, they would have not known whether they fall within the, my lord, qualified persons unless that 1:50 ratio cut off. The moment they came to know they were not within the 1:50, my lord, or they had apprehensions that they were not coming within the 1:50, it appears they have approached the Honorable Court, the first writ petition. Lord, by which date, my lord,
First
the
petition, 3 can, out of 3, 2
two
can
came,
already-
two got qualified. Lord, they apprehended probably that they were not going to be in the 1:50 ratio somewhere.
When was the results were published? What's the date of results?
Lord, 7th July, my lord, the final key was
Final key, that is, that. Final key is the result or any other?
No, my lord,
results
this-
were-
I'll just get that.
Because these writ petitions are filed subsequent to declaration of
Yes,
results. Yes, proceed.
Yes, my lord. Lord, after this, my lord, now I'll only take your lordships through, my lord. Their entire plea, as I read, my lord, 5 prayers,
Yes.
first writ petition, there is nothing to do with the key. And the person who actually raised the objections is already qualified. Lord, in 3 petitioners, third petitioner is the only one who raised the objections, but he is qualified. First petitioner also is qualified. Only third petitioner, my lord, is raising, lord, for the first time he comes before the court, he has not raised an objection. Therefore, my lord, whether the writ petition is maintainable at all,
Yes.
what would be his right that is infringed? Lord, his remedy to file objections were there if he was aggrieved. 5 days. He never files an objection there. Lord, he, after that, my lord, only this writ petition is filed, my lord. Therefore, my lord, my respectful submission is, he had a right to make an objection, and he did not make an objection within time. Now, my lord, he cannot come out, my lord, after the entire selection is almost to the preliminary stage is done. He cannot come back and say, because he is not selected, he is taking a chance, my lord, cancel the entire preliminary notification. And then, my lord, he also takes that the earlier directions, my lord, of the Honorable Division Bench was to conduct a preliminary exam and so on and so forth. My lord, then they should have come at the first point of time. My lord, to this aspect, my lord, there are several judgments on the Estoppel and, my lord, also. Lord, in this case before your lordships, my lord, 2017 4 SCC 357.
Yes.
This is this is also a case, my lord, where the Honorable High Court was pleased to quash a earlier appointment. My lord, your lordships may kindly be taken to para 1, my lord, at page 359 of.
Yes.
Lord, 3 lines down, my lord. The division bench set aside the judgment and order of the learned single judge, by which selections made by promotion from class 4 to class 3 post in district court of so and so were quashed. The division bench has held that the original petitioners who succeeded before the learned single judge in challenging the process of promotion were stopped from doing so, having unsuccessfully participated in the selection process. Lord, your lordships may kindly be taken to para 9 of this judgment. There also, my lord, after the cancellation,
Yes.
para 11, I'm sorry, para 11, your lordships.
I'm not there doesn't mean that you don't give me a copy. Please give me a copy also.
I have given, sir. Just
Just now, yes.
asked.
Yes, already given, sir. Yes,
Please keep on giving copies in my absence also. I can still answer
But
you.
the,
yes, yes.
but the basic issue that was addressed before the division bench was that the appellants having participated in the fresh round of selection could not be permitted to assail the process once they were declared unsuccessful. On this aspect, a brief recapitulation of facts would be in order. In the original process of selection, following of issuance of general order so-and-so of district court, my lord, that's the facts, my lord, of how it has happened. The principal, my lord, the first 3 lines, if your lordships have seen para 11, the basic issue that was addressed by the division bench was that appellants having participated in the fresh round of selection, not earlier round was squashed, they participated in the fresh round of selection, could not be permitted to assail the process once they were declared unsuccessful. That is the issue, my lord. My lord, para 12,
Yes.
my lord, directly on this point,
Yes.
the appellants participated in the fresh process of selection. If the appellants were aggrieved by the decision to hold a fresh process, they did not espouse their remedy. Instead, they participated in the fresh process of selection, and it would only upon being unsuccessful that they challenged the result in the writ petition. This was clearly not open to the appellants. The principle of estoppel would operate.
Yes.
Lord, then, my lord, law on all this, on this point, my lord, all the judgments have been again, my lord, narrated. It's that is the only point, my lord, which I am trying to address. My lord, para 19, your lordships may kindly be taken, my lord.
Yes.
In the present case, regard must be had to the fact that the appellants were clearly on notice when the fresh selection process took place that the written examination would carry 90 marks and interview 10 marks and so on. So the appellants participated in the selection process. Moreover, 2 other considerations weigh in balance. The High Court noted in the impugned judgment that the interpretation of rule was not free from vagueness. There was in other vagueness no glaring or patent illegality in the process adopted by the High Court. There was an element of vagueness whether the rule 6, which was dealt with promotion, merely incorporated in the act in the requirement of an examination provided in Rule 5 for direct recruitment to Class 3 post, or whether the marks. So moreover, no prejudice was established to have been caused to the appellants by that allocation of 90 and 10. The question, my lord, that remained, the decision of so-and-so which was relied upon involved would have found. The para 21, in this view of the matter, the division bench cannot be held to be in error, coming to the conclusion that it was not open to the appellants, after participating in the selection process, to question the results once they were declared to be unsuccessful. During the course of hearing, my lord, then who were ultimately selected, my lord, here also again, my lord, this court is informed that 4 out of 6 candidates who were ultimately selected figured both in the first process of selection as well as so-and-so. One candidate is stated to have been retained. Lord, therefore, my lord, once the first selection process is set aside, lord, by the Honorable High Court, lord, when the second process has been initiated, my lord, by cancellation or by whatever means, lord, having participated, they are not, lord, they are stopped from challenging the same. Lord, a catena of judgments were placed by my lord Learned Senior, lord, in respect of selection processes, and that is selection process. Lord, that step is already way far, my lord. The Honorable Court, my lord, took cognizance of the manner in which the exams were conducted. Exams were set at naught. Therefore, there was a direction to conduct fresh preliminary exam. My lord, while conducting fresh preliminary exam, there were changed circumstances, my lord, of reservation change, poster points, my lord, and also selection process. GMS number 29, my lord, changed the process of selection. My lord, that came to be changed. Indent, my lord, adding 60 vacancies, my lord, fresh vacancies which fell vacant subsequently also were directed to be notified. My lord, given taking all this into consideration, my lord, Public Service Commission felt there is necessity to cancel the earlier, because there is nothing that has gone forward except, my lord, the applications.
Yes.
Except applications, my lord, if I may say, my lord, by the directions of the Honorable High Court, cancellation of the preliminary exam, now nothing went forward except applications. Now, no vested right in favor of any persons.
Yes.
Now, there is no selection that has taken place. Therefore, my lord, cancellation of a notification, my lord, was a conscious decision taken by the Public Service Commission to ensure that these rules, the reservation also, my lord, 10%
Reservation,
is.
one is reservation.
Second is, my
one
lord, selection process of GMS number 29, my lord, came in,
Yes.
my lord, that also had to be applied.
What is the third ground?
Addition of vacancies, 60 vacancies, my lord, the indent was sent by the honorable, my lord, by the government, my lord, to add. Therefore, 503 vacancies were there. My lord, again conducting for 60 would be futile, my lord. Therefore, 563, so that many people will get an opportunity, one-time opportunity, and will resolve a duplicity of matter. The conscious decision was taken. Lord, in fact, one of the grounds that was also argued or urged, my lord, that Public Service Commission has no power to cancel the notification. That in fact, the notification itself clearly says, my lord, there was an attempt made or effort being made, my lord, to say that the withdrawal or cancellation would mean different. till such stage, my lord, it is all within the domain of the Public Service Commission, my lord, and the Public Service Commission, my lord, draws its powers from Rule 25 of the Public Service Commission rules, my lord, and it's explicitly said so in the notification.
Yes.
The power is also, my lord, explicitly made clear in para 18 that, my lord, the selection, again, my lord, I'll just read. Commission also reserves its right to alter or modify conditions laid down in notification during the entire process of recruitment and selection, or withdraw or cancel the notification at any time, duly intimating details thereof to all concerned as warranted by any unforeseen circumstances arising during the course of the process as deemed necessary by the Commission at any stage. My lord, as I have already, my lord, expressed, no vested right. All the preliminary exams, my lord, which were conducted were cancelled by the Honorable High Court. We are set at naught. But therefore, my lord, the new indent, the change in law, all this, my lord, the Public Service Commission has to follow the change in selection process, which is, my lord, given by the state government. It also has to apply the rule of reservation, my lord, which is also mandate of the state. It also has to, my lord, ensure that the 60 new vacancies which are now given also should be part of it, because it cannot keep continuing, not giving 2-3 notifications, my lord. It felt necessary, it cancelled. Therefore, my respectful submission is, my lord, the state government has only given the intent and the procedure and the rules. The Public Service Commission was very well within its right, my lord, to cancel the notification, because several litigations have come up, my lord, and also there were new change circumstances.
Yes.
And new vacancies also mandate was given. Therefore, my lord, my respectful submission insofar as the ground, my lord, that cancellation is without power, my lord, fails, because the rules enable the power to the Public Service Commission. It's a constitutional body, my lord, and the rules are framed, my lord, in accordance with the powers and my lord, under 315 and 320 of the Constitution of India.
Yes.
My lord, insofar as the other grounds, the second and third ground, my lord, they say that it's contrary to the division bench order and Honorable High Court. My lord, with great respect, my lord, the Honorable High Court, my lord, has set aside the preliminary exam directed to reconduct. My lord, by way of a fresh notification or not, my lord, is not the case. My lord, examinations were set aside, directed to conduct fresh examination. So we conducted a fresh examination now. In fact, they all participated. After participation, after 8 months, more than 3 lakh people, my lord, took the exam. Very casual attempt, my lord, to say, since I am now at this stage, after nearly final selection key is also published, cancel entire thing after 8 months. They should have done it at the first point. My lord, more than 3 lakh people are there. 35,000 people have been shortlisted, my lord. It couldn't be taken so easily at the instance of 3 or 10 people coming before this honorable court. My lord, in fact, the second writ petition, my lord, they challenge the preliminary examination also. Second writ petition is also alternative prayer is challenged to the preliminary examination. My lord, having participated, it applies there also, my lord. Having participated, one of them objected, my lord, not qualified. Therefore, now you say cancel everything, because the questions, there is ambiguity in questions and other things. You cancel and redo the preliminary examination is their case. But in this case, it's not about ambiguity in questions. This action is in violation of the division bench orders.
Yes.
But my respectful submission is, my lord, in both these cases, my lord, cancellation of the examination, my lord, may not be a case, because the commission has exercised its powers validly, my lord, and there is no illegality that has been committed, my lord. In fact, we have strictly abided by the orders of the honorable single judge, my lord, confirmed by the honorable division bench. We conducted the preliminary exam again. That is the point, my lord, insofar as 21239 is concerned.
Yes.
Therefore, my lord, in the first case, out of 3 petitioners, 2 are qualified. 1 is not qualified, who has not raised any objection.
Yes.
All have participated, my lord. It's not a case for any grant of order, my lord. In my respectful submission, the writ petition, my lord, first one, my lord, no interim orders can be granted at this stage. And if there is any final hearing that your lordships, my lord, intend to take further, my lord, we would, for the preliminary, my lord, nature of order now, there cannot be any relief granted to them. Very well. This is almost the same.
In these 2 writ petitions.
Very well. In this also, my lord, this is the case, my lord. There is no right accrued in his favor because he has not objected in the first case, the second petitioner. And Estoppel applies because they have participated and they have, my lord, now they are changing their stand and challenging the questions. But so far as the 1 and 3 are concerned, since they are already into mains, my lord, there is no reason for their sake, my lord, cancelling the notification, my lord. Therefore,
Yes.
the first writ petition, my lord, may have to be dismissed on that ground, my lord, that there is no legally vested right, no right that has been, my lord, affected,
Yes.
because they have not, my lord, taken, they have not been vigilant enough. My lord, insofar as second case is concerned,
Yes.
my lord, second case, your lordships may kindly be. Lord, in this, my lord, 5 writ petitioners have sought, my lord, your lordships may kindly be taken to their prayer. My lord.
Yes.
Declaring the, my lord, the prayer A, B, two
Yes,
prayers,
right.
my lord.
Yes.
Declaring the action of the first respondent in not considering the objections raised, that is very objections raised to the preliminary key objectively, and revise the key before publishing the list of candidates who cleared the preliminary examination. And this and illegal, lacking, and violative of so and so. Second one, well, consequently cancel entire preliminary exam and hold the same, duly taking care in both setting question paper and finalizing the key, or in the alternative direct the key be revised if necessary by referring the same to the independent body. My lord, your lordships may kindly be taken to, my lord, their pleadings, para 9.
And what did results were published?
Um,
7/7 is final key.
Final key.
This writ petition is filed on 11/8.
Yes, ma'am.
11/8.
I'm sorry, my lord. Same day, my lord. 7/7.
Same day.
Same day, my lord.
Yes.
Final key and the results were
Yes.
published.
You are referring to which para?
Lord, para 9, your lordships.
9 of the writ-
Affidavit, my lord, in
Affidavit.
writ petition number.
2232.
Yes, my lord.
Yes.
The petitioners herein have responded as per the appropriate procedure prescribed in the web note, where the preliminary key was published, pointing out the incorrectness of the key. As stated supra, no serious thought has been spared to the objections raised by the petitioner, and as such, none of the objections raised by them have been accepted. There were 14 questions, thereby 14 questions were corrected based on an erroneous key. It is necessary to state number of questions in the preliminary key examination 150, 10% of the marks have been assessed on the based on the wrong key itself, with direct bearing on the correctness. My lord, and para 10, my lord, again, they refer an error in the examination, which is the foundation of essential appointment, is bound to jeopardize the event merit, which had to be only basis on which selections on to the top of the executive post in the state government are to be made. Lord, this is him. In view of the fact that any amount of persuasion with the PSC did not result, much less positive action of at least referring the objections, my lord, again objections, to an expert on the subject to find the veracity or otherwise of the objections raised by the petitioners. They are left with no other option except to knock the doors. My lord, in fact, I have just, my lord, supplied this small table, my lord. The questions which they have raised, my lord, are the,
1 minute.
I'm sorry. I have another copy.
Yes,
Yeah, my lord, I have.
you got, it. Yes,
My lord, the second page, if your lordships may kindly
Yes.
take into. Except the petitioner number 1. These are the questions, my lord, which they have referred in the writ petition. My lord, which they claim to have raised objections. My lord, except petitioner number 1, my lord, Damodar Reddy, all the other 4, my lord, in respect of these 14 questions which they have raised in the writ petition, they have not raised any objections in the 5 days. My lord, therefore, my lord, they cannot now, once they have not accrued, my lord, taken objections at the relevant point of time, my lord, trying to join into matters, my lord, where one person, my lord, has raised an objection, my lord, does not arise. They have not exercised their right to object. They cannot be given a, my lord, fiat in this court, my lord, by this honorable court to join into a litigation and take benefit. They are all not qualified, my lord. And then your lordships would see question number 41, my lord, only one petitioner. In the other petitioner, out of 3, 2 were qualified, my lord. In this case, my lord, 5 are not qualified.
yes,
Petitioner number 1 is the only one who has raised the objections. And question number 41,
yes,
Lord, he raised the objection. Lord, we verified. He got 1 mark for it because he has answered it correct in, Lord, consonance with the key published by the Public Service Commission.
yes,
Lord, in fact, petitioner number 3 also answered correct. Petitioner number 5 also answered correct as per the key. Though they have not objected, my lord, but they have given correct answers. Then, my lord, question number 66, my lord, was the other objection which they have raised.
yes,
But this is with respect to the road. Question 66, my lord, I'll
Yes.
just read. My lord, page 15. My lord, counter your lordships may kindly take it. 22320
yes,
of 2024.
yes, page 15.
Yes, ma'am. 13, my lord.
13, yes.
13, I'm sorry. But before that, we have also stated one of the conditions that we have while, my lord, giving the hall tickets and, my lord, the question papers also, my lord, one of the condition is that choose the nearest appropriate answer. It would not mean, my lord, they should go A plus B is equals to C. I don't find C. There is answer wrong, question wrong, everything wrong. My lord, this is a group 1 exam. Logical thinking, analytical thinking is all under test. But it is not like a small first class, second class, my lord, mathematical formula. I get 1 plus 1 is equals to 2. If I don't find 2, everything is wrong. But they have to apply, my lord, their conscious head onto the question. And any nearest answer also, my lord, which satisfies those conditions also with the knowledge that they had to answer. Lord, your lordships may kindly see question 66 at page 13.
Yes,
That this question, my lord, consider the following statements related. Lord, it only says related to Mumbai Trans Harbour Link. It's a road bridge connecting Mumbai city and Navi Mumbai. It's a bridge connecting Navi Mumbai, and Lord, that's a statement. Lord, now what they say is this is the correct answer. This is the only answer, my lord, which is correct. A only is the correct answer, my lord.
yes,
Their objection is it says sea bridge. Lord, sea bridge, road bridge, both words are used on the online portal. I will take your lordships through, my lord. Both are used. So you cannot simply say it is sea bridge alone. The important factor that is there, my lord, it related to, my lord, consider the following statements related to so and so. It is a road bridge connecting Mumbai city with Navi Mumbai. My lord, that is more important. Bridge connecting Mumbai city with Navi Mumbai.
yes,
Lord, this, my lord, your lordships would find the question 66 at page 44. We have filed the document, my lord, from the website of, my lord, Mumbai Metropolitan Region Development Authority.
yes.
The first,
66.
yes, my lord, the first line itself, my lord. Mumbai Trans, my lord, and
Page number?
40, 6, my lord, I'm sorry, 46.
Yes, read.
The Mumbai Trans Harbour Link is an under construction road bridge connecting Indian city of Mumbai with Navi Mumbai. Lord, what is the next line, my lord? Is again, when it is completed, it would be called longest sea bridge is another thing. But the first statement, the road bridge connecting the Indian city of Mumbai with Navi Mumbai.
Yes,
Lord, would be relatively, if your lordships would see page 13,
yes,
it's a road bridge connecting Mumbai city with Navi Mumbai.
yes.
It's an exact line. Lord, they say there is an ambiguity, therefore delete the question. It's wrong. Lord, there is no reasoning required, my lord, on the face of it. If they can't understand that a bridge connecting Mumbai city with Navi Mumbai, they can't find any other answer. Sea bridge is not at all there, my lord. They try to find answers to get the question deleted, that's all. And this is, my lord, word to word, it is the first line, road bridge connecting the Indian city of Mumbai with Navi Mumbai at question 66, page 46, reads with the statement A, road bridge connecting Mumbai city with Navi Mumbai.
Yes,
Word to word, my lord, it is identical. There is no inferential process that is required, my lord. It is, the correct answer is A. They have got it wrong.
according to them, which is the correct answer?
They say that road bridge is wrong, it says sea bridge. Therefore, question is wrong. Delete the question.
Yes,
The statement is wrong, delete the question. My lord, that is the understanding, my lord. Out of 3,02,000 people, 155 candidates made objections to this, my lord.
yes.
3 lakh people, only 155. And out of those 155, my lord, before your lordships, my lord, only one petitioner.
Yes,
And my lord, I fail to understand, my lord, the words are identical. Your lordships would see page 46, the line, my lord, again at the cost of repetition,
yes, read.
is an under construction 21.8 kilometers, my lord. Your lordships got it, my lord.
Yes,
Then your lordships would read this sentence, that road bridge connecting the Indian city of Mumbai with Navi Mumbai. Statement A, your lordships may, Lord, kindly, Lord, compare both, my lord. It's a road bridge connecting Mumbai city with Navi Mumbai. That is the answer we have said, that's A. They say it's a sea bridge. Therefore, question is wrong. Answer is not there in the question and answer, therefore delete. Therefore, my lord, that objection, my lord, is not a valid objection. On the face of it, my lord, it shows their comprehensive levels. At a group 1, my lord, they should be very seriously, my lord, looking at how to find correct answers. They can't show this kind of understanding, my lord, showing a road bridge, my lord, this sea bridge is not there, therefore this entire statement question should go. They should find, my lord, it's a very apt answer, straight answer. They know it's a road bridge. Therefore, my lord, this objection, my lord, has to go. This question and answer both are absolutely perfectly valid. Merely because this road bridge is there, it is not sea bridge, they want the question to be deleted. Incidentally, my lord, all of them answered this question. They should have left it unanswered. All the petitioners have answered this question. Whatever they felt, they just marked it. Now they want to challenge it, saying it's a sea bridge, that bridge, this bridge, underwater bridge, it's not there. And next they will say underwater bridge also.
yes.
Once it collapses or whatever.
Look who is talking.
My lord, and my lord, question, then your lordships may kindly see, my lord, question 68.
Yes,
My lord, the next question is, my lord, 68.
79.
79, I'm sorry, I've taken the objection, 79. 79, my lord. 79, my lord, I have your lordships may kindly be taken, my lord. This is a very peculiar case, my lord. They showed Telugu Academy book. They have last time, my lord, placed before your lordships a Telugu Academy book. My lord, page 280. My lord, we are relying on other books as well.
Yes,
Incidentally, page 281. of the same Telugu Academy book reads something else. Like they didn't place before your lordships, my lord, may be permitted to. I'm sorry, 204, my lord, this is 204. They have relied on one
Yeah, they have filed this copy, yes.
they filed, my lord, page 1. Your lordships may see their reply also. my lord.
193. They have
190
filed at page 82
of their
of their writ petition. No. No, this is regarding Mahasangita, not that. 1 minute.
my lord, they filed it along with the reply, my lord.
Yeah.
Reply page.
I have filed that, my lord.
Page-
That was page 193 regarding Shaivism and Jaivism.
Yes, page
82 filed along with my counter. I mean, my main petition.
Page 54.
82 regarding Sangika.
Page
Mahasangita.
That is regarding conflict of Shaivism and Vaishnavites. That is page 82. That the internal page of the book is.
Yes, social
193.
conditions, yes.
Yes, my lord.
Under Kakatiyas, my lord.
Yes.
This
82. Why is my petition?
my lord, yes, my lord. Page 82.
You are
your
referring
lordships.
to this copy.
This is from Telugu Academy, my lord.
Yes.
And I've also, my lord, got a copy of that Varabrahma Shastri Gandhi. That's also another, the same book which they relied.
Read this Telugu Academy.
Yes, my lord, Telugu Academy. Telugu Academy. Lord, Telugu Academy, page 204, bottom. Lord,
Yes.
where your lordships would see the temples of pujaris called so and so became powerful.
Yes.
The tolerance among all religious sects of the period. Lord, during that time, Lord, here your lordships are saying the policy of religious tolerance of Kakatiyas towards other religions helped in sowing the seeds of tolerance among all religious sects of the period. Tolerance, my lord.
Yes.
During that time in Karnataka, this is very important. In Karnataka, conflicts and disturbances between Veerasaivas and Saiva sects developed, and the same we don't find in the Andhra Desha because the tolerance policy of the Kakatiyas.
Okay, yes.
Therefore, my lord, the answer which they were trying to project is D is wrong. My lord, A, B, C is only correct. A, B, C, and D. My lord, all the 4 answers were correct.
Yes.
They said that it is, my lord, they are not tolerant. In their own book, the same Telugu Academy book which they were relying. Then your lordships will also see, my lord, next page, page 205 of the same document, my lord, which I have given.
Yes.
That just above Kakatiya's service to the language, like this,
Yes, like
Kakatiya
this.
kings respected all religious sects, understood the essence of all, and encouraged religious tolerance among their people. Their authority spread into Telangana, Andhra, and Rajasthan. But they had, in Karnataka, the disturbances were there. But in Kakatiya's control, my lord, in Andhra and other places, there is no such disturbances. In general, my lord, the question that we have placed, that we have put up, my lord, I'll read the question, my lord, for lordships. Consider the following statements about the religious conditions under Kakatiyas.
Yes.
Shaivism flourished. That is not in dispute, my lord. They are not disputing. Jain temples were destroyed. That is also not being disputed. No Vaishnavacharya was mentioned in any of the inscriptions of the Kakatiyas. That is also not in dispute. There was no rivalry between Shaivism and Vaishnavism in general. Lord, they tried to show, my lord, that there is a conflict. Lord, from their own book, Lord, there is no such conflict during their period. My lord, the tolerance levels was very high insofar as Telangana and Andhra region.
Yes.
Lord, and another document also, my lord, which they relied upon was Parabrahma Shastri,
Yes.
Lord, this document. My lord, they filed page 280.
Two eighty.
In their reply, my lord.
Reply consists only 80 pages.
I'm sorry, my lord. I'm sorry.
Reply consists only 80 pages, 81 pages.
No, my lord, this is the book, my lord.
Page
I'm sorry, my
number,
lord.
yes.
Page number.
Yes, yes, page
I'm sorry.
52.
52, my lord. I'm sorry.
52 per 1 minute.
Lord, I'm sorry, my lord. I stand corrected. The Telugu Academy book, my lord, your lordships have seen, it's clear, my lord. And also the PV Parabrahma Shastri, one more document, my lord, which I have just
Page 48 of reply.
reply, yes, my lord. Yes, my lord. Page 47, they relied on the very same document, my lord, which if your lordships would see the book, my lord, which they have
This is
relied.
different one. This is by
Same, my lord. PV Parabrahma Shastri, Kakatiyas of Warangal. It's just
Yes.
that copy is neat copy.
yes.
I'm sorry, in general editor, my lord,
Editor
is
is
different.
different,
Editor is different. But by the author is the same.
Yes.
Then your lordships would see this one, my lord, at page 281, which I have just given, my lord. This, yes, my lord, this one.
1 minute. Yes.
This is published by Government of Telangana, Hyderabad. Like this.
Yes.
But again, as far as Andhra is concerned,
Yes.
the sectarian conflict between Veerashaivas and the followers of other faiths did not develop into religious conflicts, as in Karnataka.
Yes.
During that period, it was all due to the tolerant attitude of the Kakatiya rulers that the society at large could rather assimilate than vehemently oppose the doctrine of other sects. But here also tolerance, there is no, my lord, in general, there was no conflict of, my lord, between the other sects.
Yes.
My lord, insofar as, my lord, two documents, my lord, which they are relying, Telugu Academy, the same author, PV Parabrahma Shastri. Apart from this, we have also placed, my lord, along with our counter, I'm sorry, my lord.
Yes.
Lord, your lordships would find at page 67,
57.
my lord, 67, my lord. I'm just sorry, I'll just take your lordships.
That's at page 55 of the counter, my lord, edited by one Mr. G.
55.
That's what
Yes,
I
sir. I'm sorry. Yes, ma'am.
Page 57, paragraph unnumbered paragraph 1, 4 lines from the bottom. That is what they were relying on.
Yeah, this is also same, my lord, again. Same document, my lord. It's just that we have given another copy, my lord, a neat copy. It's the same document which we relied upon. This is question number 79, even from Telugu Academy, my lord. It's very clear, my lord, that they had tolerant levels. Lord, the book which they referred, my lord, and we referred, both of them say that insofar as Karnataka, there is a difference, but insofar as Kakatiya here, my lord, there has been a tolerance level in general. Therefore, my lord, this question answer also, lord, is correct, my lord, insofar page, my lord, 105. Page 60, my lord, 60.
Page
60, my lord.
This was the question.
Not
which
six,
is
my lord,
that, perhaps
plate
the
60.
benefit of doubt can go to the public service commission. This is where, my lord, I was trying to say, extending the principles laid down by the Honorable Supreme Court. If
yes.
Only 18 have objected. 1-8. None of the petitioners have objected. They are now raising
None
it.
of the petitioners are raised.
None of the petitioners have objected, my lord. In fact, if your lordships would see the table, my lord.
Yes.
112, none of them objected, and very surprisingly, my lord, from the first writ petition, my lord, of my lord 21239, all the three petitioners have got it correct. In tune with the Public Service Commission final key, all the three have answered it right,
Yes.
and they have never objected. 112, no one objected.
Yes.
In fact, only 18 in the entire state have objected. None of them have ever raised objections. And first writ petition, all the three have attempted. They got it right also. In second writ petition, my lord, it's different case, my lord. All of them got it wrong.
I interrupt, my lord. We got right for a wrong answer. We gave a wrong answer. That means we gave a wrong answer. We got a mark. We don't want that. We don't want but mark.
But cannot be. That's,
No, no.
they never
My lord,
objected, my lord.
No, no, my lord.
Yes,
They never objected.
We'll come to you. Please wait.
I'm
Please
sorry.
wait. We'll hear you. Yes.
They have never objected, my lord. And in the first writ petition, fortunately, they got it all right also. So therefore, my lord, 112, even I'll just read, my lord, for the sake of reading. Question number 112, match the following authors with their words.
Yes.
My lord, an example was given on the other day, my lord, with William Shakespeare and Serena Williams.
Yes.
Lord, the words are totally
No,
different.
not this.
This is the one, my lord.
No, no,
In this
no,
case
no,
only, my lord, is
That is regarding Thivanet item.
no, my lord.
No, not this one.
I'm sorry, my lord. I'm sorry. In this case, my lord, Singama Nayaka,
Yes.
Peddana, Ananta, Jakana.
Yes.
Lord, what their objection is, there should be Singama Nayaka 1, Singama Nayaka 2, Singama Nayaka 3.
Only 1 and 2. Not.
It's not specifically given. That's what, my lord. It's not specifically given. Therefore, the question is wrong. Lord, there is only one Singama Nayaka, 1 or 2, my lord. The name is same. Lord, there
Yes.
can't be any difference.
Yes.
That's where, my lord, the hall ticket very clearly says appropriately nearest answer. They, when they know that it's so and so person, my lord, they could have simply, my lord, identified. But however, my lord, only 18 people have objected. None of the petitioners have objected. In the entire state, 18, and petitioners are not among those 18.
Yes.
We have given that statistics, my lord, in page 19. Question number 112, my lord. In 21.
Same 7. Question number 112, 113, 114. Nobody has filed an objection.
Nobody, my lord.
112, 113.
Nobody. In the second case, only the first petitioner has raised the objections, my lord. Second, third, fourth, fifth has not raised the objections to any questions.
Yes.
And that also, my lord, 112, 113, 114, they have not raised objections.
They are not. Yes. What about
My lord, 113 is something, my lord, which my
Yes.
lord, and senior was referring to, my lord, Jean Thevenet. My lord, this case, my lord, I will only I'll not trouble your lordships, my lord. In fact, we had to get the original book.
Now,
But they have not filed objections to this question.
No one filed an objection, but however, my lord, we just thought,
Yes.
my lord, I'll just, this marks are there, my lord. The original book.
Sorry.
Lord, I'll just read and then place it before your lordships, my lord. It's Jean de Thevenet. And then, my lord, here says travel by Indies. Travel into the Indies is the case, my lord. I'll just pass it, my lord.
Yes.
M.D. Thevenet is what they were saying, my lord. They were trying to refer it to a different name.
Yes.
Lord, we said it's Monsieur, it's a Mr. M. Lord, in this book, the original book, it's referred as Mr. D. Thevenet. And what is his full name, my lord? How that other person which they are referring to is his nephew who has never traveled beyond the continent. Only this person, my lord, has traveled 34 countries in his life. Lord, that is his name and details, my lord. I'll just place it for your lordships. He is the only one who has authored, who was in India at that point of time, my lord, in Golconda. Okay. Just Lord, the first line in the second after Roman 2, the first name,
Yes.
full name.
Jean de Thevenet was born at Paris on
Yes,
6th June 1633.
And he is the author, my lord, who has traveled all through. My lord, I'll read, my lord. He died near the small town of Miana in Persia while
Show
returning
from
to
your
his,
material you have filed along with counter.
this same thing, my lord, we have filed. Lordships, we gave one or
So
two
that they
pages.
can also follow it.
Yes, ma'am. We gave one page, my lord, but looks like it was not sufficient. We had to
Yes.
get the entire thing. It's page 64 of the counter.
Yes.
Lord, travel of so and so, so and so. This is the original. Lord, the same book, my lord, is also placed before your lordships.
Yes.
In this, it is very clear, my lord. The Roman 2, I'll just read, my lord, a little bit of it. My lord, during this brief span of 34 years, he had visited more countries of Europe, Asia, Africa than many of his contemporaries
Where are you
ever
reading?
heard of.
Where
My lord,
are
I'm
you-
sorry, my lord.
Where do you get that copy?
We have book, it's book, my lord, that same para 2, my lord, your lordships were looking at.
Wait, para 2, yes.
Jean de Thevenet was
Yes,
born
during his
at
this brief
Paris.
span of 34 years.
Yes, my lord, Paris in so and so. He died near a small town so and so. During this brief span of 34 years, he had visited more countries of Europe, Africa than many of his contemporaries ever heard of. An ardent studies of geography, natural sciences, he has arduously studied, accounts of early travelers in which his uncle, Lord, this is his uncle so and so was keenly interested. The elder Thevenet long survived his nephew, but he never crossed the limits of his continent. Lord, this Melestivish is what they were referring to. Is his uncle who has never traveled beyond the continent. It's only Jean de Thevenet who has actually traveled around.
Yes.
And he is the traveler. The question now your lordships would see, my lord. Page 20. Name the foreign traveler who visited Golconda in the month of Muharram and reported clashes between Shia and Sunni of Muslims. Lord, he is the only one.
Yes.
No, question 113, my lord.
Yes.
Name the foreign traveler who visited Golconda in the month of Muharram and reported clashes between Shia and Sunni of so and so. Lord, the first one is the correct answer which we refer to. They say this question itself, these answers are wrong because it's not Jean de Thevenet, it's M. Thevenet.
Yes.
They claim Melchedish, my lord, which is his uncle, Lord, who never traveled beyond the continent. Lord, therefore, we had to bring the original book also, my lord, which is in his name. And this talks about travel by Indies, my lord, by him only, which they themselves have referred. If your lordships would see their reply, in their reply, my lord, they have referred to this. Lord, page 92. They have referred, my lord, in their book. It talks about travel de Indies. My lord, in the travel in the Indies is the book, my lord, which talks. But however, my lord, they have not raised an objection to this question. My lord, this is one more, my lord. 113 also, my lord, they have not raised any objection. 114.
This is 113, yes.
Yes, my lord. 114 also they have not raised any objection, my lord.
Yes.
But 114, my lord, two petitioners in second writ petition have got it correct. Though they have never raised an objection, my lord. No one has objected. All the 8 of them have not objected, my lord.
Yes.
And that, my lord, 38% have, that is also, my lord, Qutub Shahi style of architecture, my lord. That question, my lord, the answer that we have given, the lordships may kindly be taken, my lord, for a minute.
Patan, not Mughal.
Not Patan, it's Patan, not Mughals. All through, my lord, in every document, even if your lordships
Show
would
the
get,
material.
my lord, even your lordships may kindly be taken to the Digital Telangana website, my lord, of Hyderabad Government of Telangana at page 69, 68.
Yes.
68, my lord.
Yes.
These tombs are present in large number on a raised platform. They resemble Persian, Pathan and Hindu architectural styles and make use of grey granite with so and so. Even the website, my lord, of the state government, which refers to the, my lord, Qutub Shahi tombs, tourism, my lord, website, also refers that as a Pathan only. And then, my lord, a study of history and culture of the Andhras, my lord, that also
Page
page 70.
70. Yes.
My lord, 71, bottom, my lord.
Yes.
There also, my lord, Sultan Kuli's new buildings at Golconda, according to Yazdani mark the evolution of new style in Indian architecture called Qutub Shahi style after the name of the dynasty. According to him, it's a mixture of Persian, Hindu and Pathan styles. My lord, therefore, there is a my lord, even the next one again, my lord, the page 72 also your lordships may.
Yes.
This is also by another publication. Now, there also art and architecture at page 73.
Yes.
But it became a part of Qutub Shahi architecture. The architecture style of Qutub Shahi is combined Persian, Pathan, Hindu. Therefore, my lord, most of the documents, my lord, which have books, textbooks, my lord, which have been referring or, lord, with the history, lord,
Yes.
refer to these 3 styles only. Though no question, no one has raised an objection, my lord, only to clarify to the honorable court, my lord, that there is
Yes.
nothing wrong with the question and the answer.
Yes.
Except their understanding, my lord, they felt because, my lord, Mughals have ruled us for so many years. My lord, the general tendency to think is Mughals are always Mughal structures, Mughal, my lord, architecture. But this is not a case in Kuli Qutub Shah, my lord. This is with respect to Pathans. My lord, and question 116, they have already dropped, my lord.
Yes.
And your lordships may kindly be taken to, my lord, question 119, my lord.
Yes.
This is the case, my lord, where one senior said, my lord, it's a light pressed case. My lord, in this case,
How many candidates answered this?
Constitutional. My lord,
How many candidates answered this right?
yes, my lord.
How many candidates put right answer?
My lord, objections, my lord, right answers, my lord. Right answers also. In fact, just for the sake, my lord, I'll just take before that, my lord, 119 of the counter your lordships may kind.
Yes.
My lord, this is National Commission website for Scheduled Caste and Scheduled Tribes. Page 77.
Yes. 77.
Yes. Of the counter affidavit.
Yes.
Now, this is the website of the National Commission for
Yes.
Scheduled Caste. The losses may kindly be taken to page 78,
Yes.
Article 2.7, my lord. Economic safeguards.
Yes.
The heading itself, my lord, says economic safeguards. Article 23, 24 and 46 form part of economic safeguards for scheduled castes and scheduled tribes. The provisions of articles 23 and 24 have already been discussed in earlier paragraphs. This is from their own website, National Commission for Scheduled Caste and Scheduled Tribes. No better answer can be given, my lord, from their own website, from the website of, my lord, National Commission for Scheduled Caste. My lord, I would say this, my lord. Article 23, my lord, and 24 talk about child labor and human trafficking. Most of the times, this human trafficking and child labor is, my lord, economically weaker sections or, my lord, socially economically backward are prone, my lord, to uplift and to protect them majorly. My lord, to economic, that kind of, my lord, economic safeguards were provided because, my lord, in 1950 when India became republic, my lord, the state of affairs in the country, my lord, were very different. Right, all these articles 23 and 24, if your lordships would, my lord, look at the status of affairs, my lord.
Answers given right answer for this
Lord, I have
out of these 8 candidates.
but these 8 candidates, my lord, lordships have seen. Only, my lord, only 2 have raised objections out of 8 candidates.
Yes.
My lord, the remaining no one, and 1 person, my lord, has is already selected.
Yes.
My lord, only Damodar Reddy, my lord, in the second writ petition has raised an objection. On the whole, also, I am just getting that information, my lord. How many?
Yes. Yes.
Each question ki how many they got right and wrong. Total. I'll get that information, my lord. There is a data for that also. But in so far as this is the last question, my lord, if your lordships would see question 119, that is from the website of the National Commission. My lord. That's as direct as we can put, my lord, placed before your lordships. My lord, so far, therefore, my lord, all the questions, my lord, which have been referred by learned seniors, my lord, are not wrong, my lord. Their answers are also very clear.
Yes.
From the books and, my lord, from the books, textbooks, and also, my lord, even from their books also, my lord, where we are placed. There is nothing wrong in the question or the answer. My lord, it is more about group 1, my lord. They have to apply their, my lord, mind around it. There can't be a direct answers to all the questions. My lord, when the question says, my lord, economic safeguards of SC STs, my lord, it doesn't mean you have to find only where scheduled caste is seen. My lord, any articles from the Constitution of India which come to the rescue or economic safeguards also has to be considered. My lord, it can't be like, my lord, 1648 talks about SC ST, therefore that is the only one. Others cannot be. That any article of the Constitution of India which comes to the economic rescue.
Read the question.
Yes, my lord. I'll just read. Page 25, my lord. I'm sorry.
Yes.
Which of the following article of the Indian Constitution is not related to economic safeguards provided to scheduled castes? That 23
one article is not related to.
Yes, my lord. Only one. 23, 24, 46, my lord. We have shown that they are falling part of the economic safeguards for scheduled castes. The only one article which is not is 34. It's a it's a, you have, my lord, it's more about logical thinking, my lord. Everything will not be straight question. They put not. If they did not put not, my lord, all the three would have been the correct answers, except one.
Logical.
And your lordships would see, my lord, that's where, my lord, that's where I was emphasizing from the beginning, my lord, that this group 1 is not a case where 1 plus 1 is equals to 2. I see 2, then only correct. Like, there is a lot of logical thinking, reasoning. Like, they have to find answers. They have to do a lot of research, my lord. They can't rely on one book. If I am not wrong, my lord, most of the petitioners who have come, my lord, at least they have been relying on Telugu Academy, only one book. Like, if they find the right answer there, they are very well. If there is a wrong, they are disputing. That is the only point, my lord. There is a general study that also needs to be done insofar as group 1 and this kind of exams are concerned. Probably that is lacking, my lord, in these cases. But, my lord, 119 also, my lord, only one petitioner now, my lord, I'll get that statistics, but that if your lordships have seen, not, it's only 34. And National Commission, my lord, for schedule caste is very clear, my lord, economic safeguards for all. But I am relying on, my lord, the judgments of Honorable Supreme Court, my lord, at the cost of all these cases. Key related, my lord, I am emphasizing, my lord. One is Ranvijay Singh and others, 2018 to SCC 357. Ranvijay Singh. That this, my lord, your lordships may kindly be taken to para 19 and para 30. Para 19, my lord, I'll just read, my lord. Referring to Kanpur University, Lord, the Honorable Supreme Court further referred. In other words, the onus is on the candidate to clearly demonstrate that the key answer is incorrect, and that too without any inferential process of reasoning. The burden on the candidate is therefore rather heavy, and constitutional courts must be extremely cautious in entertaining a plea challenging the correctness of the key. To prevent such challenges, this court recommend a few steps to be taken by the examination authorities, and among them are establishing a system of moderation, avoid any ambiguity in the questions, including those that might be caused by translation. Prompt decision must be taken to exclude. Therefore, my lord, and para 30, your lordship. Lord, referring to several judgments of Honorable Supreme Court, my lord.
Yes.
Para 30, my lord, law on the subject is therefore quite clear, and we propose to highlight a few significant conclusions. If a statute, rule, or regulation governing an examination permits revaluation of an answer script or scrutiny of an answer as a matter of right, then the authority conducting the examination may permit it. If a statute, rule, or regulation governing an examination does not permit revaluation or scrutiny of an answer as distinct and prohibited, then the court may permit revaluation or scrutiny only if it is demonstrated very clear without any inferential process of reasoning or by process of rationalization, and only in rare of circumstances cases that a material error has been committed. The court should not at all reevaluate or scrutinize the answer scripts of candidate. It has no expertise in the matter, and academic matters are best left to academicians. The court should presume the correctness of the key answers and proceed on that assumption. And in any event of doubt, the benefit should go to the examination authority rather than to the candidate. Lord, in most of the questions which we have shown, my lord, that answers are based upon, my lord, textbooks and Lord, material. But the other document also, my lord, judgment. I would also rely on 1983 4 SCC 309. My lord, this was also, my lord, circulated on last occasion to your lordships, my lord. This was circulated, my lord, on last occasion 1983 4 SCC 309. My lord, Kanpur University versus Samir Gupta and others.
309. Page number?
Yes, my lord. I'm sorry. Page number 309.
No? Yes. Yes.
Lordships. Lord, in this, my lord, your lordships may kindly be taken to para 1 itself, my lord. Next page. Lord, these appeals raise somewhat awkward question. Lord, in this, it's about translation, my lord. But however, if a paper setter commits an error while indicating the correct answer to a question set by him, can the students who answer the question correctly be failed for the reason that though their answer is correct, it does not accord with the answer supplied by the paper setter to the university as the correct answer. The answer which the paper setter supplies to the university as the correct answer is called the key answer. No one can accuse the teacher of not knowing the correct answer to the question set by him. But it seems that occasionally not enough care is taken by the teachers to set questions which are free from ambiguity and to supply key answers which are correct beyond reasonable controversy. The key supplied by the paper setters in these cases raise more questions than they solve. There, my lord, your lordships are aware, my lord, a lot of translation issues came up. But, my lord, the Honorable Court, I would only take, I am relying on, my lord, para 13.
Yes.
Para 13, my lord, I'm sorry, my lord, para 15, my lord, I'm sorry, para 15. The findings of the High Court raise a question of great importance to the student community. Normally, one would be inclined to the view, especially if one has been paper setter and an examiner, that the key answer furnished by the paper setter and accepted by the university as correct should not be allowed to be challenged. One way of achieving it is not to publish the key answer at all. If the university has not published the key answer along with the test, no controversy would have arisen in this case, but that is not the correct way of looking at the matters which involve the future of hundreds of students which are the aspirants for admission of professional courses. If the key answer were to kept in this case, the remedy would have been worse than the disease because so many students would have had to suffer the injustice of silence. The publication of so and so. My lord, your lordships may kindly, my lord, skip to para 16, my lord.
Yes.
Sri Kakar, who appears on behalf of the university, contend that no challenge should be allowed to be made to the correctness of the key unless on the face of it is wrong. We agree that the key answer should be assumed to be correct unless it is proved to be wrong, and that it should not be held to be wrong by an inferential process of reasoning or by a process of rationalization. It must be clearly demonstrated to be wrong, that is to say, it must be such as no reasonable body of men well versed in the particular subject would regard as correct. The contention of university, my lord, is falsified in this case by a large number of acknowledged textbooks which are commonly read by the students in UP. These textbooks leave no room for doubt that the answer given by the students is correct and the key answer is incorrect. My lord, your lordships may, my lord, I am emphasizing here, my lord, acknowledged textbooks.
Yes.
Lord, what we have, my lord, relied upon by the Public Service Commission is all acknowledged textbooks, my lord, and reputed authors, Lord, which are being used by the Technical Council for Higher Education also. Higher Council for Education. This is not, my lord, compilation. Para 18, my lord, further goes to say, if the state government wants to avoid a recurrence of such lapses, it should compile under its own auspices a textbook which should be prescribed for students desirous of appearing for combined pre-medical exam. Education has more than its fair share of politics, which is bane of numerous problems are bound to arise in the compilation of such a textbook for various applicants will come forward for doing the job and forces and counter forces will wage battle on the question as to who should be commissioned to do the work. If the state can succeed in overcoming these difficulties, the argument will not be open to the students, then the answer contained in the textbook which is prescribed for the test is not the correct answer. But secondly, the system, my lord, they went on. But my respectful submission is, my lord, in all these cases, the Public Service Commission, my lord, while preparing the questions or the referring to the answers, my lord, has relied upon acknowledged textbooks, my lord, history documents, Lord, nothing, no stone unturned. Lord, even, my lord, the Telugu Academy is a compilation, my lord, I would rather say so, my lord, because even if your lordships would take the Telugu Academy books, my lord, there is a disclaimer which says, any errors, please inform us, we'll correct. This is not final. Lord, therefore, my lord, even if there are any mistakes, an answer cannot be said to be wrong unless it is otherwise again disproved by any other authentic textbook. We are able to demonstrate, my lord, before your lordships, my lord, that at least 2 to 3 textbooks are referring to the same answer, which we have chosen as a key. Lord, unless they are able to show that that is wrong by way of any other authentic textbook or a document, my lord, which could prove this as wrong. Lord, that is what, my lord, the judgment says, should not be interfered with. Lord, today's day, my lord, over 3 lakh people have taken the exam. Lord, and Lord, paltry, Lord, if your lordships would see, in all, maybe about 1,500, 1,200 have raised the objections, my lord. In each of these questions which they have referred to, about 80, 8, 10, 15, Lord, some 200, 150. These are the only objections out of 3 lakh people. And most of the petitioners have themselves not objected. Therefore, my lord, this is not a case, my lord, where they can raise as a public interest litigation. Clearly, my lord, as a public interest litigation, there is no personal right that is affected. They have to show how they are affected. They are coming before this honorable court under 226. Lord, what is their right? Where their right is infringed? Lord, how they can, my lord, approach this honorable court when they cannot establish under what, my lord, what is their right that is affected? When they have not made any objections, my lord, they cannot now come back and say, I have given objections, you did not consider. Fact is, they have never raised any objections. Now it is all gone past, my lord. Several persons have already been shortlisted. Few of the petitioners are also shortlisted, 2 of them. Lord, at this stage, my lord, interfering with the selection process would be, my lord, very unjust to many of the persons who have been preparing for this exam for years. Lord, at the instance of, my lord, few, hardly, my lord, 10 petitioners. Out of them, my lord, 2 are again, my lord, qualified. But one last, my lord, judgment which I am also relying upon, my lord. Lord, your lordships may kindly be taken to, my lord, para 32. Para 32.
Of the judgment.
Yes, my lord. I'm sorry, my lord, para 15. Para 15, my lord. I'm sorry.
Yes.
Examining the scope of judicial review with regard to re-evaluation of the answer script, this court in so-and-so held that the court should not reevaluate or scrutinize the answer sheets of a candidate as it has no expertise in the matter and the academic matters are best left to academicians. This court in the said judgment further held as follows. On our part, we may add that sympathy or compassion does not play any role in the matter of directing or not directing reevaluation of any answer script. If an error is committed by an examination authority, the complete body of candidate suffers. The entire examination process does not deserve to be derailed only because some candidates are disappointed or dissatisfied or perceive some injustice have been caused to them by an erroneous question or an erroneous answer. All the candidates suffer equally, though some might suffer more than that cannot be helped since mathematical precision is always one. This is an extract. Then your lordships may kindly be taken to para 16.
Yes.
In our view, above law laid down by this court is in law laid down by this court, it was not open to the division bench to have examined the correctness of the questions and the answer key to come to a conclusion different from that of the expert committee. In its judgment dated, reliance was placed by the appellants on Richard Singh versus Rajasthan Public. In the said judgment, this court interfered with the selection process only after obtaining the opinion of the expert committee, but did not enter into the correctness of the questions and answers by itself. Therefore, the said judgment is not relevant for adjudication of the dispute. A perusal of the above judgments would make it clear that the court should be listen. That page, your lordship's got counter in 22320.
Yes. Page.
Para 12, my lord, page 6, para 12.
Yes, read.
In this regard, it is submitted in total 6,417 objections have been received online from 1,721 candidates. The Commission has constituted subject-wise expert committees with experienced professors from reputed institutions from throughout the country to scrutinize all objections received from the candidates on the provisional key. While calling for the objections on the preliminary key, candidates have been asked to raise objections with relevant proof along with source and proper justifications for the stand. All the objections received from the candidates were classified according to the subject and were placed so and so. Accordingly, the subject expert committees have verified all the objections received on preliminary keys with the authentic sources. All the objections received by the candidates have been considered and examined in detail by the subject expert committees. Subsequently, the subject expert committee have furnished its recommendation on the objections received to the Commission. Based on the recommendations of the subject expert committees, the Commission has approved the final key and hosted on the Commission's website on 7/7/24. As per the report, the subject expert committee, the Commission has made only following 3 changes in the preliminary key. Question number 56, 59 is deleted. 115, the paper key recommended for key changed from 2 to 1. For deletion questions, marks were awarded by adopting the following procedure. And then para 15, my lord, the petitioners have filed writ petition raising certain objections on preliminary key and has alleged that the respondent has released the results so and so without considering their objections. All the objections on the questions raised online by the petitioners. Para 16.
Yes, yes.
I'm sorry.
Read.
All the objections on the questions raised online by the petitioners within the stipulated time have been referred to the subject experts committee, and the subject expert committee have gone through all details and given a report that all the objections raised online except in respect of 59 are
All the
invalid.
petitioners have filed objections.
No, my lord, they gave it.
Once again.
That they said, my lord, all the objections,
on the questions raised.
whatever they have submitted online, my lord, were considered. and except 59 in rest all were found to be invalid. Lord, only one petitioner in this case, one petitioner in in that case. They have raised objections. Lord, the data, my lord, also your lordships asked. But insofar as how many have answered 119 correctly, my lord, I will get that data, my lord. Even in the notification, my lord, your lordships may kindly be taken to para 11, my lord, of the notification.
Yes.
Lord, of writ petition 22320.
Page.
I'm sorry, my lord. I'm sorry, my lord. 23, the other writ petition, your lordship.
Yes, seems yes.
Lord, in 21239,
Yes.
page 119, my lord, the
Yes.
notification starts, and page 133, your lordship.
Yes.
There is a specific procedure, my lord, which was given. Resolving objections relating to questions, preliminary key and other matters of preliminary test and valuation of descriptive type examination for written mains. Now the question paper, my lord, and all of this, then your lordships may kindly be seeing, my lord, 11.3.
Yes.
The commission publishes the key on its website after conduct of preliminary test. Any objections with regard to the questions key shall be filed within the stipulated period through the link provided by TSPSC website after publication of the key. The objections received physically in the form of representation or emails are not entertained in any circumstances. Any objections received after the last date of receipt of objections on key would not be entertained. The objections received in the prescribed pro forma within the due date will be referred to expert committee for opinion to take appropriate decision thereon on the commission by the commission. Final key will be hosted as per the decision of the commission. The marks of deleted questions, my lord, then objections on final key will not be entertained. The decision of the expert committee is final. Lord, in this case also, my lord, preliminary key was published, my lord, in June. Objections were given, opportunity, my lord. Thereafter, final key is published. Lord, whatever they could have done, they should have done it at that point of time, my lord. After this belated, after the results are also declared, Lord, after 1 month, Lord, they cannot, my lord, now try to stall the entire process of selection, my lord, by, my lord, mere few writ petitioners, my lord. That too, when they have not raised any of their objections. Therefore, my respectful submission is, my lord, both these writ petitions, my lord, deserve to be dismissed. Lord, and that many of the, Lord, students, around 35,000 people now selected for preliminary exams are waiting. They are now on the brink of understanding, my lord, that there is something else. By, my lord, only 3 people, my lord, have filed and another 5 people have filed. Lord, for them to make preparations for the exam also, my lord, it's this pendency of these cases would also, my lord, hamper their preparations. Lord, your lordships may, my lord, dismiss these writ petitions, my lord. There is no right that they can, there is establishing, my lord, to maintain these writ petitions. Lord, my respectful submission is, my lord, your lords. I'll dismiss
What
the
is
writ
the date
petitions.
of publication of results?
Lord, 7/7.
7/7 only.
The final key was published on the same day, my lord. The results also were declared. And the first writ petition is filed, my lord, on 31st July. Second is filed in August.
We'll continue tomorrow.
Examination results should not be counted for purpose of written exam.
Lord, in the data, my lord, out of the test, my lord, 79,553 people have answered it correct. The 119.
Out of 8 candidates, how many candidates?
These people, they have not. Out of 8, 2 people have answered correct.
Correctly answered.
Correctly answered.
Who are they?
Petitioner number 3 in writ petition number 21239, Lord, who is qualified, and petitioner number 1 in writ petition number 22320. The one who has raised the objection. Right, it's like this, my lord. The one who raised the objection has answered it correctly in the second writ petition, but is not qualified. He's the only one who raised the objection. In the first writ petition, the only person who has raised the
Mr.
objection
Damodar
is,
Reddy.
yes, my lord. And he has answered it correct. And insofar as petitioner number 3 is concerned, in first writ petition, he has answered it correct, but is qualified also.
Yes. We'll take up this matter tomorrow, in the urgent motion list as a first item.
Yes.
So that
Yes, we don't need to.
Bless.
goes tomorrow in the urgent motion list as a first item.
Lord, the other case, if I can say, the
Yes.
other case which was item number 8, that is also maybe posted together, because in that case, my lord, their contention is whether who is right, who is wrong, who is correct, who is right. My lord, can be decided, but what they are saying, my lord, is that they have already suffered 2 preliminary examinations, and Public Service Commission has been, my lord, playing with the candidates, my lord, their time and their energies, because they have to stay in Ashok Nagar, stay in rooms and study. My lord, and then Lordship knows that Ashok Nagar is the hub. Keep on writing examination. What they are saying, what all they are saying, my lord, is please do not conduct anything. Don't take it further and then get it cancelled. Hold it till all the issues are sorted out. That's their claim. They are not
That's
saying
very
question.
far-fetching, my lord.
They
So
are-
many
they are-
petitioners
No, one
have
second,
already.
one
I'm
second,
sorry.
sir.
So
I'm
what are
only
you doing
trying-
all these days? What
No,
are you
I'm
doing
not-
all these days?
I am only saying.
7 results were published.
21 exams
No,
are to be
I'm not-
conducted from 21.
Lord, I am not saying anything, my lord. I am not. I want to write the examination. I don't mind. But the thing is, please don't allow us keep on. If this is cancelled again, we have to write the 4th examination. So what they are saying, my lord, is who is right, who is wrong. We are not interested. We are not interested in the litigation. But don't please keep on make us to write examinations. Please get everything cleared from the courts. Only then you conduct. That's all our case in the second case. We are only trying to say, my lord, please clear your slate.
Sir, please
Then-
conclude by tomorrow so that,
Yes, my lord. We will.
yes.
We are obliged for Lordship's concern, my lord, for posting it as a first case in the adjourned mostly, so that Lordships will have reasonable time.
Yes, thank you.
Obliged.
Obliged.
Item 8 post along with this.
May I make a submission, my lord? Item 161, my lord, it's a fresh matter. My lord, on last Thursday, my lord, when the matter first time came up, my lord, since my lord, on behalf of Singer and Calris, my lord, I sought time for getting instructions, my lord, the matter was urgent to list in the urgent motion list. It listed in daily list, my lord. Lordship, may kindly tomorrow in the urgent motion list, my lord.
14th in the urgent motion list, item 161.
My lord, it's a fresh matter, my lord.
Item number 160.
Let it be
Item number 90, my lord.
tomorrow, my lord, let it be in the list, my lord.
Lord, I'm sorry, my lord.
No mentions in the evening, and let it be there. Adi kuda avasram 161.
My lord, I'm
Yes.
sorry, my lord. Since my arguments have been concluded, one judgment I missed out, my lord. I thought I'll just give the paragraph numbers and leave it there, my lord.
Yes, give them.
I'm obliged.
My lord, I'm sorry to make a mention. I'm sorry.
Yes. Tell
My
us.
lord, there is one matter your lordships have directed the matter to be listed today, sports quota. The other matter came, my lord, in which your lordship gave a direction. That matter, same direction has to flow in that, my lord, where selections are over. Subject to result, your lordships have to pass, my lord. 17th it is posted. I'll give the number, my lord. Let it come tomorrow.
You should have made a mention in the morning.
No, morning, my lord. Yeah, but tomorrow your lordships can have, my lord. Subject to lordship's convenience. Same order it needs to be passed.
Maybe, but it is not correct procedure. We'll see tomorrow.
But tomorrow lunch motion will ask, my lord. Much obliged.
Obliged.